Welcome to a plea to Justice Roberts. Please protect our property. Part 1. The Flood. Hello, I'm Joe Patrina, founder of the Hoodwink.net website, examining the illegal taxation of private American homes. Initially, my focus centered on home and vehicle taxation, but lately, even our financial belongings appear in taxation's crosshairs, and this river about to flood really got me going. Recently, the Supreme Court of the United States dipped its toe into the waters of private property protections, and the timing couldn't be better. We will look at this event shortly, but first, the premise. Assessment-based taxation of private homes and family vehicles is not simply unaffordable, it is unconstitutional. And so, if we allow this ingrained habit to continue, assessment-based taxation of financial holdings will most certainly follow. To stem this, we must firmly apply constitutional brakes across the entire spectrum of property taxation. As mentioned, the court may be ready to weigh in before it's too late. Skeptics say that the Supreme Court would never overturn property taxation, but this treatise demonstrates both ample legal standing and a compelling framework for the justices to indeed take the case. The legal centerpiece: only commercial activity can be taxed, and because our dormant belongings generate no profit until sold, there is nothing to tax. We simply ask that programs such as mandated free K-12 education are funded correctly, using taxes applied to commercial activities such as sales, wages, and capital gains. We want the government to leave our dormant belongings alone, not just our homes and cars, but our hard-earned financial savings as well. We never amended the Constitution to tax the people's personal assets. The 1913 Amendment only sanctioned income taxes, and so, to this day, property still cannot be encumbered by government taxation. Why then, you may wonder, hasn't property taxation been challenged in the courts? The answer, and most people do not realize this, is that since our country's founding, property disputes have been adjudicated solely by state courts, which politically protect state budgetary agendas. The Supreme Court of the United States never accepted these cases, seeing them as local, internal state conflicts. But in 2019, for the first time, Chief Justice Roberts invited private property cases brought to the Supreme Court. For details on this ruling, see the Rosemary Knick versus the Township of Scott, Pennsylvania case. As Justice Roberts put it, we now conclude that the state litigation requirement imposes an unjustifiable burden on the property owner's claim that his or her land has been effectively taken for public benefit without the government paying just compensation. It is because of this breakthrough that I believed a property tax initiative might finally stand a chance. So I wrote this paper, both for the court and for all others out there seeking a path out of the anti-constitutional taxation maze we were hoodwinked into many decades ago. By initiating constitutional movement against the taxation of dormant homes and family vehicles, we can simultaneously arrest the recent wealth tax campaign to attack our prudent savings. To pursue this strategy, a constitutional law firm has sought to design a multi-state, grassroots class action suit against the governors, demanding they shut down unlawful home and vehicle taxation in their respective states. This landmark case would simultaneously put Congress on notice that their taxation powers do not extend into financial property. 3 layers of legal protections underpin the property appeal. It starts with our natural rights to life, liberty, and property, which sit above the reach of government. Next, 7 constitutional clauses uphold these natural rights. Finally, Court precedent demonstrates that the highest court has already protected personal property against unlawful encumbrance. As designed, American law offers a multi-layered system of safeguards to reverse the current trajectory of government overreach. And so, with the socialist flood as the big picture, we next turn to the first line of defense, natural rights. Here in Part 2, we examine natural rights. Those familiar with the legacy of Thomas Jefferson know that his concept of natural rights to life, liberty, and property still rings true. In the Declaration of Independence, natural rights are defined as inalienable, neither able to be given away nor taken away by any operation of government. New laws and executive and judicial decrees cannot interfere with natural rights. To better understand natural rights, let's examine the rights to bear arms, to free speech, and to private property found in the U.S. Constitution. First, a look at life and the right to bear arms. Quite simply, if you have a natural right to life, then certainly you have the corresponding right to defend yourself. And this means defense from all comers, including criminals and oppressive political regimes. As Jefferson put it, the strongest reason for the people to retain the right to keep and bear arms is, as a last resort, to protect themselves from tyranny of government. This natural right to life is proportionally diminished as government limits your ability to defend yourself. Hence, for self-preservation, your natural rights to both life and arms must sit above any operation of government. Next, a look at liberty and free speech. When I took a class on free speech, as taught by the dean of Yale Law School, no one in class could define the term free speech. We tried, but the dean dismantled each and every one of our guesses. Finally, he let us off the hook, explaining, everything American starts with we the people. People run the government, not the other way around. Authority over government is why freedom of speech exists. Unfettered dialogue amongst ourselves is essential for us to pilot our subordinate government apparatus. Then he continued, freedom of speech, the right to influence the political opinions of others out in the public domain, has no restraints. This includes hate speech, agenda media, and even falsehoods claimed against public officials, so long as the optic is political. Non-political falsehoods, such as defamation or yelling fire in a theater, are both illegal. Thank you, Professor. And so, because freedom of speech is a natural right sustaining liberty, it implicitly sits above government. Now, property. Property consists of anything considered yours. Your opinions, ideas, beliefs, lifestyle choices, health choices, your privacy, your real estate, and movable goods. As with life and liberty, property also sits above government, not to be encumbered. The taxing of private homes and family cars, and the idea of taxing one's financial savings all violate the property protection purpose of the U.S. Constitution. In defiance of natural rights, socialists believe that property, and even speech, stand subclassified with limited rights molded by the evolving needs of government. As it stands, the U.S. Constitution was never amended to subclassify natural rights in this manner. Such an amendment would repudiate the entire foundation of we the people, thus placing us and our property below the government. Yet even with our natural right to property specified so self-evidently, the founders, in addition, designed 7 constitutional clauses to more deeply define and protect this right. Coming up next in Part 3. Here in Part 3, we review the constitutional clauses designed to protect our homes, family cars, and life savings from government overreach. Many do not realize that 7 constitutional clauses already protect one's property from the government, including tax origination, indirect taxation, property taking, due process, contract, direct taxation, and equal protection. These firewalls absolutely forbid the taxing and taking of your home, family, vehicles, and financial savings. They are our law of the land and have never been constitutionally amended. Let's start with Constitutional Clause number 1, the Origination Clause. The Origination Clause simply states that all taxes must originate in the legislature and nowhere else. In other words, municipalities, which are places, not legislatures, possess no taxing authority. Next comes Constitutional Clause number 2, the Indirect Taxation Clause. This clause permits legislatures to solely tax money-making commercial activity, such as sales, wages, capital gains, and everyone's favorite, tolls. Because our commercially inactive homes neither make money nor create financial transactions, they cannot be taxed until sold. As for Constitutional Clause number 3, the Property Taking Clause, it narrowly authorizes property taking for eminent domain public use projects, such as building a highway, where the owner is fully compensated. No other taking is permitted. Yet some municipalities criminally take and sell homes from under people to collect the taxes their state legislature never levied in the first place. Through what are called non-judicial takes, municipalities brazenly bypass Constitutional Clause number 4, the Due Process Clause, which requires judicial review of all property matters. Instead, municipalities directly confiscate homes to collect taxes. Thankfully, there are federal laws on the books to protect us from invented misdeeds such as these. For instance, municipal institutions using invented tax authority to intimidate households into paying made-up taxes are operating a classic RICO syndicate, violating the Racketeer Influenced and Corrupt Organizations Act. Now let's examine Constitutional Clause number 5, the Contract Clause. In the American liberty system, individuals are supposed to live unencumbered. Parties only become obligated through mutual arrangement called a contract. The rule is no contract, no obligation. And in case you didn't know, municipalities are regular corporations, no different than McDonald's, Walmart, or General Motors. Corporations cannot impose unilateral contracts on you simply because you reside in their district. Again, parties must mutually agree for a contract to be enforced. And as we all know, most homeowners are not under contract with their municipal corporation. But here's the rub. Most homeowners are under contract with their mortgage lender. And to obtain a mortgage, banks obligate homeowners to pay these illicit taxes. Then there are those who own property free and clear. Without a bank acting as the heavy, many municipalities revert to raw taking of these homes and do so without court involvement. One crime, bogus home taxation, leads to the next crime, wanton taking, both trampling the residents' civil rights. Let's next look at number 6, the Direct Taxation Clause. Interestingly, direct taxation, a long-forgotten clause, allows both real estate and people to be taxed, but only at some uniform amount. For example, $1,000 per year for each person over the age of 21 to pay for local road maintenance and police. Congress's last use of direct taxation was after the War of 1812, when each adult had a chip and a standard amount to pay for the war. Uniform direct taxation across the population is the only property tax option sitting in the government's constitutional toolbox. and strangely, it's never used. Instead, unconstitutional assessment-based taxes are levied. In other words, your local tax assessor projects a false authority in setting your tax obligation. In court, projection of false authority by government officials constitutes yet another crime called color of law. Finally, in our quest to protect property, there is number 7, the Equal Protection Clause. Supposedly, everyone should be treated equally under the law. Yet municipalities habitually award side deals to privileged taxpayers. Sadly, this gross behavior is never prosecuted, as state-level justices allow their fellow state municipal friends to essentially do whatever they want. But there is hope. Never forget that in America, our natural rights to life, liberty, and property stand inalienable, neither able to be given nor taken away, even though faulty precedent has trashed these rights for decades. This means that with the stroke of a pen, Supreme Court intervention could rightfully end the taxation of dormant homes and family automobiles and block any attempt to tax one's financial assets. Free K-12 education and state administrative code programs can continue, but only if funded by the legislature using sales income and other transactional taxes. And so, with at least 7 constitutional clauses violated and many criminal statutes ignored, a dilemma of this magnitude belongs up with the Supreme Court of the United States. The question then becomes, will the highest court consider overreach cases and stand for we the people, or similar to local courts, rule for their counterparts in government? But there is precedent to help them deliberate. Let's look back in time and revisit a few property right cases coming up next. Here in Part 4, we review settled law, property cases that generally obligate future Supreme Court decisions. In the late 1900s, numerous cases involving property appeared before the Supreme Court that set the stage for protecting all classes of property in today's political climate. For example, in the Snyadock versus Family Finance Corporation case, Mr. Snyadock challenged the constitutionality of a Wisconsin wage garnishment procedure. A finance corporation alleging Snyadock owed it money filed a garnishment complaint. In compliance with the Wisconsin state law, Snyadock's boss withheld half of Snyadock's wages. As expected, the state courts supported the 50% garnishment action as prescribed on their own books. And so it took the Supreme Court of the United States to reverse the decision. Justice Douglas, writing for the majority, stressed the fact that an interim freezing of the wages from the filing of a garnishment action to the time of the trial was as serious as permanent deprivation of property and may, as a practical matter, drive a wage-earning family to the wall. The majority considered wages property, needing protection under due process. The majority also expressed concern over the tendency of garnishment to deprive Snyadock of a realistic judicial settlement because of the pressure to quickly settle and thereby pacify his employer. Here the court blocked an extortion dynamic. What would the court think about a municipality threatening home confiscation to collect property taxes, especially taxes they had no authority to levy in the first place? Another due process case showed the Supreme Court's perspective regarding property confiscation. In the Fuentes versus Chevin consumer case, Mrs. Fuente stopped sending an appliance merchant her monthly payment for a gas stove after a disagreement arose on servicing the stove. At this point, the merchant filed for repossession of the stove in conformance with Florida law. By virtue of this Florida statute, Mrs. Fuentes was owed no prior notice and was allowed no opportunity to challenge the repossession. At first glance, this appears to be about fair timing of notices, but during litigation, many of the property protection principles were cited that today could easily apply to confiscation of one's home, and not just a gas stove. These principles include substantial deprivation, regardless of notices. The court deemed the taking of a stove to be substantial deprivation. Necessary property. The stove was necessary property needed to live. Grievous loss, any substantial and adverse impact on one's private interest is sufficient to require due process protection. These rulings can apply to deprivations of all property. How about one's home or life savings? So far, the highest court has not faced a private property case where confiscation of assets takes place, even without a breach of a commercial contract as the basis. This brings us to today, and the aforementioned Supreme Court of the United States ruling inviting property cases brought to the highest court. Until now, home property cases were not accepted by the highest court, with the court considering these states' issues. But are they? When states go beyond eminent domain taking and brazenly grab private homes to collect taxes, their illicit behavior squarely defies the Bill of Rights. Either through ignorance, corruption, or neglect, state judges let this unholy practice stand. This may be why Justice Roberts opened the door. I hope he does not close it. Next, in the final segment, we summarize the court's choices. In this final segment of A Plea to Justice Roberts, we examine why due process protection of property needs a fresh reaffirmation by the highest court. Please recall that the 5th and 14th Amendments to the United States Constitution each contain due process clauses. Certainly, these clauses protect citizens from unfair prosecution, but due process protects something even more precious. As its priority, due process prevents any popular majority from debasing the life, liberty, and property of the current minority. Thankfully, in America, getting into public office does not grant someone the privilege of running roughshod over everyone else's birthrights. Still, with all this in place, the time has finally come for the Supreme Court to reaffirm the basic American premise, to assure us that political outcomes will never undermine natural rights. Fortunately, to protect natural rights, the Supreme Court often blocks the creation of vague narratives designed to muddy up the waters, similar to today's equity justice narrative. Interestingly, Lysander Spooner describes examples of vague narratives back in the 1800s. He explained it this way: legally speaking, the term public rights is as vague and indefinite as are the terms public health, public good, public welfare, and the like. These have no meaning. Due process, therefore, ensures the minority rights of citizens against the various forms of tyranny, including made-up law. Which brings us to this. Under the current U.S. Constitution, neither popular voting, activist judges, executive orders, nor legislation can authorize wealth-taking from one's home, bank account, investment portfolio, or any other asset simply to fund municipal, state, or federal budgets. It's all made-up law. And because socialists know they cannot validate their made-up laws through amendment, they instead bully society through clever workarounds such as ignoring criminal, constitutional, and election laws, inhabiting deep state power jobs, dominating the media and academia, and using street terrorism and big tech cancel culture armies to smother the opposition. The point? This behavior cannot be voted out of office, and so politics cannot be relied upon to blunt the authoritarian flood about to submerge all classes of property. One might recall that in recent times, the Supreme Court passed on intervening into both Obamacare and election fraud, as it deemed these conflicts better addressed through political channels. But property is different. By definition, our natural right to property rides above politics. And so, by issuing a fresh landmark ruling, the court would establish a modern firewall protecting property within the current political climate. As a result, many aspects of American society would be reset. Government would become more frugal, school choice could blossom, and certainly the average citizen might better navigate life knowing he or she owned their possessions free and clear. In America, it always comes back to property, a pure constitutional issue, one that can only be solved by the highest court and not through retail or state politics. In my words, the government is not in charge of everything, and certainly not in charge of my house, my car, or my savings. So the question becomes, are we to be a nation of inalienable natural rights to unencumbered property or not? I pray that the court takes on such a case and not be bullied into staying quiet by political threats of court packing. I ask the court to reinstate America's law of the land, retire all forms of property taxation. Don't let politicians and media campaigns manipulate you.